Welcome everyone to our Judicial Watch educational panel, holding President Obama accountable to the rule of law. I'm Tom Fitton, President of Judicial Watch. Judicial Watch is a conservative, nonpartisan educational foundation dedicated to transparency, integrity, and accountability in government, politics, and the law. And through our educational activities, we advocate high standards of ethics and morality in our nation's public life and seek to ensure that public officials do not abuse the powers entrusted to them by the American people. Judicial Watch strongly believes in the rule of law, and to that end, obviously, a government that adheres to the limits imposed upon it by the U.S. Constitution. So you can imagine the Obama administration has been a challenge to us. Our panel today, entitled Holding President Obama Accountable to the Rule of Law, will discuss the various approaches, including a planned lawsuit by the House of Representatives to challenge President Obama's series of unilateral executive actions that critics contend violate federal law and exceed his constitutionally enumerated powers. You know, of course, holding politicians accountable to the law, to the rule of law is core to Judicial Watch's mission. And simply put, there is a rule of law crisis in this town. President Obama has displayed an astounding lack of respect for the Constitution, the other branches of government, and the American people. He's undermining the U.S. Constitution and turning it into what the Founding Fathers feared most, a mere parchment barrier being ripped to shreds by a power-hungry chief executive, what they refer to as a monarchist. In the words of Thomas Jefferson, to appoint a monarchist to conduct the affairs of a republic is like appointing an atheist to the priesthood. President Obama's proclivities are most apparent in his refusal to accept the process of working to build consensus to pass legislation in Congress. He blusters that if Congress won't act as he sees fit, he will. As he told a joint session of Congress earlier this year during his State of the Union address, "I'm eager to work with all of you, but America does not stand still, and neither will I. So wherever and whenever I can take steps without legislation, that's what I'm going to do." You know, it isn't as if we hadn't been warned. In the run-up to his 2012 re-election, Obama pushed an executive power grab under the guise of a "we can't wait" campaign. Obviously, he couldn't wait for Congress again. Between October 2011 and the end of his first term, 2011 October was when he first announced this, President Obama undertook approximately 11 executive actions as part of this "we can't wait" campaign. Whether using these unilateral executive actions to violate and thwart laws against illegal immigration, to enact a mortgage relief program, revamp the student loan debt program, strengthen the FDA's power to ration prescription drugs, or unilaterally amend the historic bipartisan welfare reform law, President Obama has shown neither reticence nor reluctance in undermining the system of checks and balances that have served this country so well for so long. In Federalist Number 58, James Madison wrote, "An elective despotism was not the government we fought for, but one in which the powers of government should be so divided and balanced among the several bodies of the magistracy as that no one could transcend their legal limits without being effectively checked and restrained by the others." He also noted in Federalist Number 51, Madison, that in a Republican government, the legislative authority necessarily predominates. The legislative authority necessarily predominates. All presidents must come to grips with this fundamental principle of American democracy. And I'm sure, this panel might have been very different during the Reagan administration, during his fight with Democrat-controlled Congresses, maybe even during the Bush administration. But conservatives have to remain principled no matter what the party and no matter how the government is divided. So as you know, President Obama is not the first, nor will he be the last president to use a pen and a phone to work his way around a Congress that does not share the chief executive's governing vision. But his assault on our Republican form of government is really historic. Even the left-leaning constitutional law professor Jonathan Turley, he wrote in a March 2014 commentary in the Los Angeles Times, he recognizes that the president's contempt for Congress would have shocked the framers of the Constitution. And he wrote, Obama's not a dictator, but there is a danger in his aggregation of executive power. The United States is at a constitutional tipping point, the rise of an uber presidency unchecked by the other two branches. Mr. Obama's aggressive executive directives and unrestrained agency rulemaking are overshadowing Congress's constitutional rule-making law. And to its great shame, until maybe recently, the Congress is making this presidential usurpation of congressional powers easier by largely ignoring its constitutional obligation to defend its prerogatives and check over an overreaching president acting in clear violation of his oath of office. Let's take a look more specifically at the president's attack on our immigration laws that he took an oath twice to faithfully execute. For years, the administration has been quietly implementing a stealth amnesty scheme for illegal aliens in defiance of Congress. Then, in 2012, in June, the stealth effort was institutionalized in the open when Janet Napolitano, who was then Department of Homeland Security Secretary, issued a memorandum formally establishing the Deferred Action for Childhood Arrivals program without any statutory basis and direct defiance of Congress's earlier refusal, I think repeated refusal, to enact the so-called DREAM Act into law. And this deferred action is known as DACA around town. Now, the DREAM Act would have allowed certain immigrant students who grew up in the United States to apply for temporary legal status and eventually obtain permanent legal status and become eligible for citizenship if they went to college or served in the U.S. military. And it would have eliminated a federal law that penalizes states that provide in-state tuition without regard to immigration status. Again, that was rejected repeatedly by Congress. Maybe good, maybe bad. Either way, it was rejected. DACA, which President Obama implemented after this legislation was rejected, directs the U.S. Customs and Border Protection, the U.S. Citizenship and Immigration Services, and the U.S. Immigration and Customs Enforcement to practice, quote, prosecutorial discretion towards some individuals who immigrated illegally to the United States as children. In other words, to decide unilaterally which part of the law the Obama administration will enforce. On June 6, 2013, the U.S. House of Representatives voted to defund this illicit DACA program, but the U.S. Senate obviously did not follow suit. This is a good example of the new normal under President Obama. Rather than Congress passing legislation and the President signing or vetoing it, as the Constitution provides for, in Obama land, first the President establishes programs, and then the Congress is forced to repeal them if it doesn't like what the President has done. Executive action first, legislative action afterward. The President is ignoring the law, failing to enforce the law, and otherwise rewriting the law at whim and then saying to Congress, catch me if you can. Since DACA's inception, well over 550,000 illegal aliens have been granted this Obama amnesty in plain violation of the law. Not only does this usurpation of congressional authority undermine the Constitution, it also weakens security on the nation's border with Mexico. So in practice, if an illegal immigrant can make it across the border, or frankly even to our border these days, there is little chance under DACA and the President's other amnesty-type policies of being deported. This amnesty lawlessness has led to more illegal immigration in the current border crisis, and ironically has prevented, at least for now, this president from abusing his office further with other amnesty executive actions. President Obama can't even be bothered to follow his signature achievement, the Affordable Care Act, his Obamacare law. By some counts, he has violated his own law 24 times. You know, Ulysses Grant said, and I'm paraphrasing, the best way to ensure the repeal of a bad law is to enforce it vigorously. Well, President Obama knows that, and that's why he's ignored key provisions, such as the employer mandate, which subjects large employers to tax penalties if they don't offer affordable minimal health care insurance coverage to their employees, which is, we had been told, one of the pillars of the law. The law, that part of the law was supposed to take effect in January 2014, the first day of the year. But on July 2nd, 2013, the administration postponed the mandate until 2015, after the elections, and then earlier this year delayed it again until 2016. I could go on and on about this president's lawlessness, which is really a fundamental challenge to our system of governance. But again, the question for this panel is how to restrain the lawlessness and hold this president accountable to the law. Direct legal challenges can certainly work. The Supreme Court, for instance, has brushed this president back repeatedly on his overreach, most notably on his abuse of the recess appointment power. The court ruled 9-0 that the president abused his authority. He couldn't even manage to get the votes of his own two appointees to bolster him. And Judicial Watch is in the midst of a legal challenge to the violation of the law on the employer mandate on behalf of Kawa Orthodontics out of Florida. The lawsuit initially was rejected by a lower court on standing grounds, but we're confident that the U.S. Court of Appeals for the 11th Circuit, which will hear arguments in the matter next month, will find that our client has standing. This lawsuit ultimately will force the administration to follow his own law. You know, under our Constitution, Congress has a variety of ways of holding a president accountable to the law. Funding, oversight, appointments, legislation, and of course impeachment are only part of the tool chest available to a Congress united in trying to check a president. Recently, the U.S. House of Representatives voted to try the Judicial Watch way and authorize a lawsuit in federal court directly challenging the illegal delay of the Obamacare lawsuit. This historic action may or may not survive court scrutiny, but it should be noted that never before, as best I can tell, has an entire House of Congress challenged the president's lawlessness in federal court. And the question obviously for the courts, does the court, as a body, have standing to challenge a president in court over this type of lawlessness? Or is the House dodging its constitutional responsibilities by refusing, for political reasons or practical reasons, to use oversight, the power of the purse, or the impeachment power in an aggressive fashion? In other words, giving to the courts the job that it ought to be doing through Congress. Of course, one way to police the presidency is to demand and enforce transparency. We filed 3,000 Freedom of Information Act requests with the administration and over 160 lawsuits to demand that the administration follow the law and produce documents about what it is up to. Between just Benghazi and the IRS, little old Judicial Watch has done more than the Department of Justice, the media, and Congress to expose key facts in those scandals. Scandals of a nature, by the way, which may have caused previous presidents to resign or be removed from office. Now, getting back to our panel, we can't do much better than our esteemed guests in terms of our discussion about holding President Obama accountable to the rule of law. And to my left is Bob Goodlatte, a congressman who represents the 6th Congressional District in Virginia in the United States House of Representatives. In the 113th Congress, Congressman Goodlatte was elected as chairman of the House Judiciary Committee. He also serves as vice chairman of the House Ag Committee, and is serving in those leadership roles. He is co-chairman of the Bipartisan Congressional Internet Caucus, another power grab area for this president, and the Congressional International Anti-Piracy Caucus, and is also chairman of the House Republican Technology Working Group, again, another area of presidential overreach. He's a graduate of Washington Lee University School of Law, and he got his undergraduate degree from Bates College up in Maine. Joining me on my right is Andy McCarthy, who's a best-selling author, a senior fellow at National Review Institute, and a contributing editor at National Review. His most recent book, published in June, is, let me move this microphone so they can pick me up better, is Faithless Execution, Building the Political Case for Obama's Impeachment. He's a well-known commentator on legal, national security, and political affairs, and you see him on Fox News and everywhere else. He also writes for PJ Media and the New Criterion. Frankly, more importantly, he's, if I may be so bold, he's a former chief assistant to a U.S. attorney in New York, where he was best known for leading the prosecution against the blind sheep, Omar Abdel Rahman, and 11 other jihadists for waging a terrorist war against the United States, which included the 1993 World Trade Center bombing and a plot to bomb New York City landmarks. After the 9/11 attacks, he supervised the U.S. Attorney's command post near Ground Zero, and he later served as an advisor to the Deputy Secretary of Defense. So, you know, between Chairman Goodlatte, who's running the Judiciary Committee, and obviously he's taking a lead role in trying to highlight recently Obama's lawlessness, and Andy's new book, which puts out that issue of impeachment on the table in a way that is not as aggressive as you would think, but is very thoughtful and needs consideration. We've got pretty much all the bases covered here. So what we're going to do is that our panelists will make some comments, and they can go as long as they need to, and then we'll open it up for discussion here, and then some questions from our audience. And be warned, when we have a congressman here in the middle of the week, anything can happen, and the chairman may be called out suddenly for votes and other matters. So we understand that your time is precious here. So please, Congressman Goodlatte, we're pleased to welcome you to Judicial Watch.
Well, Tom, thank you very much. It's a pleasure to be here, pleasure to be with you. I very much appreciate and admire the work of Judicial Watch in standing up for the rule of law. I'm also pleased to be here with Andy and with all of you to talk about what I think is a very important issue, and indeed is a constitutional crisis when it comes to respect for the rule of law here in our federal government. In his first inaugural address, President Ulysses Grant observed that he knew, quote, "no method to secure the repeal of bad or obnoxious laws so effective as their stringent execution." Many have suggested that this adage would be especially true if applied to Obamacare. However, rather than enforcing the provisions of Obamacare, the President has unilaterally set aside or amended dozens of provisions in his signature health care law. He has done this because the law remains as unpopular as ever, and strict enforcement of the law as written would likely lead to its repeal. The President has gotten away with ignoring so many Obamacare provisions because the obverse of President Grant's adage is true as well, and aptly summarizes the danger to democratic government posed by the Obama administration. The best way to keep a bad law on the books is to allow its selective enforcement. But without enforcement of the law, there cannot be accountability under the law, and political accountability is essential to a functioning democracy. If the President's unconstitutional assertions of power are allowed to stand, this and future presidents will be able to treat the entire United States Code as a mere set of guidelines, selectively choosing which provisions to enforce and which to ignore. If a bill the President signed into law was later considered to be bad policy or harmful to the President's party if enforced, accountability for that policy could be avoided by simply delaying enforcement until a more politically opportune time, if at all. No longer would presidential candidates running for re-election have to stand on their records because their records could be edited at will. This is why the House of Representatives has decided to file a lawsuit to declare that the administration must enforce Obamacare as it is written. The House cannot allow President Obama to continue to ignore the constitutional limits of his authority. The danger posed by the accumulation of powers in the executive branch is much more than a turf war between politicians. Both the horizontal separation of powers among the branches of the federal government and the vertical separation of powers between the federal government and the states, or federalism, were designed to protect Americans' individual liberty. By dividing governmental powers, the Constitution's framers sought to prevent the abusive concentration of power in any one branch of government. This is because the framers, who were intimately familiar with English history and law, understood that the aggregation of governmental power was the greatest threat to liberty. Thus, all Americans, whether Democratic, Republican, or Independent, should be concerned with the danger posed by a president who can unilaterally ignore the separation of powers as a matter of presidential prerogative simply based on his or her policy preferences. As Professor Jonathan Turley, who you cited, testified before the House Judiciary Committee that he voted for President Obama, he also warned at the committee The problem with what the president is doing is that he's not simply posing a danger to the constitutional system, he's becoming the very danger the Constitution was designed to avoid. That is, the concentration of power in a single branch. In place of the Constitution's command that the president is to take care that the laws be faithfully executed, President Obama has proclaimed that, quote, "I refuse to take no for an answer, and that where Congress won't act, I will." Certainly, presidents from both political parties have, from time to time, made broad claims of executive power. However, these assertions of authority have, at least traditionally, been limited to the area in which presidential powers are at their strongest, foreign affairs. President Obama's far-reaching claims of executive power, if left unchecked, will vest this and future presidents with broad domestic policy authority that the Constitution does not grant. The president's deliberate pattern of circumventing the legislative branch in favor of administrative decision-making must be addressed, and the House's lawsuit against the administration will do just that. The courts have held that lawsuits alleging institutional injuries must be brought by the injured institution itself, and the House lawsuit is solidly in line with those precedents. The Supreme Court has never closed the door to the standing of the House as an institution. It has had the opportunity to do so on many occasions, and each time it has refused. Indeed, the courts routinely hear lawsuits involving the enforcement of subpoenas approved by federal legislative bodies. They do so because the subpoena power of each House of Congress derives from its legislative powers. When the executive branch refuses to give a congressional body the information it requests, it impedes the legislative power, and the federal courts regularly hear those cases. But today, the president is not only impeding the legislative power, he is negating it. And if the federal courts can hear cases in which Congress's legislative power is hampered, they certainly should be able to hear cases in which legislative power is nullified. The Constitution's framers did not expect the judiciary to sit on the sidelines and watch as one branch aggrandized its own powers and exceeded the authority granted to it by the Constitution. Rather, the Constitution gives the federal courts very broad jurisdiction to hear, quote, all cases arising under this Constitution and the laws of the United States, end quote. The court should not refuse to exercise a vital check over unconstitutional action by the executive branch. When the courts decline to step in and umpire these disputes, they cede the field to this and future presidents. The separation of powers is not strengthened by the refusal of the judicial branch to referee the division of power between the other branches. As then-Senator Obama observed in 2008, one of the most important jobs of the Supreme Court is to guard against the encroachment of the executive branch on the power of the other branches. And I think the Chief Justice has been a little bit too willing and eager to give an administration, whether it's mine or George Bush's, more power than I think the Constitution originally intended, end quote. The House's lawsuit will be a good step toward checking the executive branch and restoring balance to our system of government. Although it is true that when the president fails to perform his constitutional duty to take care that the laws be faithfully executed, the Congress has appropriations and other powers over the president, none of those powers can be exercised if a Senate, controlled by the president's own political party, refuses to exercise them. Without the cooperation of the Senate, the House's litigation against the president may be the only way to restore political accountability and enforce the rule of law. The stakes for inaction are high. As English historian Edward Gibbon famously observed regarding the fall of the Roman Empire, quote, the principles of a free constitution are irrevocably lost when the legislative power is dominated by the executive. It is up to Congress and the federal courts to check the accumulation of powers by the executive branch and thereby preserve the individual liberty of all Americans. Thanks, and at the appropriate time, be happy to
Thank you, Mr. Chairman.
Answer questions and elaborate.
Thank you, Mr. Chairman. Andy McCarthy.
Thank you so much, Tom, and it's a great honor to be here at Judicial Watch, and in particular with Congressman Goodlatte. And I must say, I do agree with a good 80 to 90% of what the congressman said, particularly his remarks at the end about the wages of inaction. And that's important because there's no issue that animated the framers of the United States Constitution as much as exactly what Congressman Goodlatte talked about, the possibility, the danger that the executive branch would accrete to itself, usurp the powers of the Congress. There was no evil that they worried about more than the possibility of the concentration of the executive power and the legislative power in the same hands. To the Congress, to the framers of our Constitution, that was historically the surest road to tyranny. And they gave a great deal of thought about how best to prevent that from happening. And what they essentially laid out in the Constitution, I think it's important to talk about the Constitution because if we're going to discuss the rule of law and whether we can rein the president in so that he has to honor the rule of law, the Constitution is the highest source of our rule of law. In the Constitution, the framers gave us two ways, essentially, to rein in executive lawlessness. They are very difficult ways, but they're also dispositive ways. There are, however, only two of them. One of them is the power of the purse, and that was the one that the framers assumed Congress would resort to the most. And the idea would be if the president exceeded his authority, either the money could be cut off that allowed him to do that, or Congress could use its power of the purse in a way to generally punish executive excess in order to inspire or give the president the incentive to conduct himself lawfully. The second way was impeachment. And impeachment was something that was to be invoked in the event of high crimes and misdemeanors. There's also treason and bribery, but I'll leave those on the side because high crimes and misdemeanor is mainly the target we're talking about. High crimes and misdemeanors does not refer to crimes and misdemeanors of the type that I had to try to enforce back when I was a federal prosecutor. It's actually a term of art that was borrowed from British law, which the framers were well versed in. And what it relates to is profound acts of government maladministration. It's not required that the president take action that actually violates the law in order to commit impeachable offenses. What the framers talked about were breaches of the public trust. The term high crimes and misdemeanors actually is much more redolent of concepts that we find in military justice rather than in the penal code. Ideas like dereliction of duty and the failure to follow an oath, including very much the oath to take care that the laws be faithfully executed, which is, of course, domestically speaking, the most important oath that the president takes. The framers, I think, also recognized that we're a body politic, not a body legal. They wanted to make sure that there was a clear legal standard for impeachment, and I would submit that the concept of high crimes and misdemeanors is such a standard. But the second thing they wanted to make sure of was that the impeachment power was not invoked frivolously, that there had to be a broad-based consensus among the country that the president needed to be removed from power. So in addition to laying out a clear standard for high crimes and misdemeanors, a clear standard for removal from power, they also required that for a president to be removed from power, that a two-thirds vote in the Senate would be required. And what that would necessitate would be that there would be a broad enough support in the public for the notion that the president had to be, or it was appropriate to remove the president from power, that you would actually proceed with impeachment. And as I argue in the book that Tom was kind enough to mention, the only real reason to ever go down the road of impeachment would be to remove the president. I don't think there's any moral victories in this. You can file articles of impeachment in the House with a simple majority, but if the president can't be removed from power, it's actually, I think, a tactical error to begin your way down that road, because what we know would happen would be if the president were impeached in the House and inevitably won his impeachment trial in the Senate, that would be spun by the White House and the media as a vindication of the way that Obama has governed for the last 6 years. So far from cracking down on executive lawlessness, which is the goal, you would, in the end, inadvertently, I think, have probably encouraged more of it. So I think those are the two real options. Let me talk for a couple of minutes about the lawsuit, which I think, while well-intentioned, is not much of an option for cutting back on executive lawlessness. And I think that's clear simply from the fact that, we started talking about the lawsuit, I think, back in the spring. We're now in September, and we're still talking about maybe filing the lawsuit. And then the lawsuit will be filed at some point. And then perhaps it gets spun out to one of the hundreds of judges that President Obama has appointed in the district courts. And perhaps that judge overcomes the standing challenges that Congressman Goodlatte's remarks were, I think, directed to overcome. But let's assume, for argument's sake, that you get past all those hurdles. You get a judge who is willing to overlook standing. You even get a judge who's willing to rule against President Obama. What happens then? The interesting thing is we're talking about a president who's lawless, right, which is the reason that you're in court in the first place. The premise of the lawsuit is that the president is going to honor a judgment of the courts against him. And we've seen, Tom said in his remarks, direct legal challenges can work. Well, they can work to a certain extent, but I think the recess appointments case that he mentioned actually suggests the opposite. Yes, the court ruled against the president, and the recess appointments were held unconstitutional. What's the substantive result of that? The judgments that were made by the appointees are all, that went on for over a year, I believe. None of those results have been invalidated. And think about the Arizona case. The court ruled against the Obama administration on the main aspect of the law that Arizona put in place about the ability of the police to interrogate illegal aliens. The very day that the court made that decision, the Obama administration announced that it was going to cease cooperation with the state authorities of Arizona in immigration enforcement. This is an administration which has shown as much contempt for judicial decisions that go against it as it has for the statutes that it finds inconvenient in carrying out its objectives. And why does it feel confident in doing that? Well, the framers thought that the judiciary was, as they put it, the least dangerous branch. And that was because it would have no arsenal, it has no power of the purse, it has no attribute to speak of other than judgment. And what that means for present purposes is it also has no means whatsoever of enforcing its own rulings. So I think essentially where we're at with the lawsuit is that Congress is asking the court to decree something that everybody already knows, which is that the president has conducted himself lawlessly. The question isn't whether we can get a declaration of whether that's happened. It's happened. Everybody knows it's happened. The question is, what do we do about it? And the unfortunate fact is the judiciary, even if it could work at a pace that could keep up with President Obama's lawlessness, has no capacity to roll it back. it needs the cooperation of the other branches, particularly the executive branch, to carry out its orders. So I admire the lawyers and the members of Congress who are behind the lawsuit and who are doing what I think is the only thing that can and must be done under these circumstances, which is we have to create a political environment where executive lawlessness has consequences. But I must say, given the structure that we're in and given the Constitution that we have, if you take impeachment off the table, which essentially has been done, and maybe it's done as much by reality as it is by people simply saying we're not going to go down that road, and you take the power of the purse off the table because you don't want to have the political weight of being held responsible by the media for shutting down the government, you can rant and rave, you can complain, you can file lawsuits, but you can't rein in presidential lawlessness. And I think, if I may, the most important thing that Congressman Goodlatte said in his remarks was his allusion to the precedents being set for this and future presidents. I think that was, I think I've got what he said correct. And he's quite right about that. Presidential lawlessness ought not be a conservative or liberal issue. It ought not be a Democrat or Republican issue. Every future president will be able to exploit the precedents that President Obama is setting now for government, unilateral government by the executive branch. That ought to be something that we can rally the public around. And I think that before you can change the reality that we're dealing with, you have to change the political environment. And the only way that we can do that is to make people understand what the wages of presidential lawlessness are and what they portend for the future in terms of our regard for ourselves as a government or a society governed by the rule of law, a nation of laws and not men. Thank you.
Thank you, Andy. I appreciate it. It'd follow Chairman Goodlatte. Certainly the political atmosphere way of changing the political atmosphere, it seems to be at least relevant in terms of if what we presume the president is saying is accurate, or the prognostications about why he's doing certain things are accurate, meaning that there was a seeming willingness to change further immigration law or ignore and rewrite it, that he delayed in light of either the border crisis or political reaction from within his own party or strong reaction from Republicans in the House and the Senate. You know, I don't know whether to believe any of that. Maybe he wasn't going to do it at all. He was just trying to get people excited before the election. But does that suggest that Andy may have a point there, and certainly address any of other points you'd like to address more directly?
Well, I actually believe all of that. And the proof, I think, is in the fact that he's already done, as you noted in your remarks, a major usurpation of power by creating the so-called deferred action for childhood arrivals. This is taking a small, important piece of our law that gives prosecutors discretion on not prosecuting some of the tough cases and turning it on its head and having that exception swallow the rule, which is if you're unlawfully president of the United States, you're required to leave the country. If you don't leave voluntarily, you're required to leave under the government's actions, and instead allow people to stay and give them work authorization and other benefits from doing that. So the idea that having done it for 550, 600,000 people, he might do it for 5 or 6 million or more people is entirely to be concerned about if you believe in the rule of law. So I think that what happened at the border was very much mishandled, and it's an ongoing problem, by the way. The news media's attention span is not always as long as it should be, but that's an ongoing problem. I think the political consequences with Democratic candidates for office suggesting that this might create a backlash, I hope and think it would. But I also think that the comments by the Speaker of the House and myself and others that this would not go unaddressed, including the potential of going to court and seeking an injunction, is a part of that process. So when you're talking about the judgment of the court in a lawsuit like we're talking about, the limitations that Andy described are certainly there. But ultimately what you're talking about is the judgment of the people. And the more times you can find ways to pin back someone who is abusing power, whether it is through spending limitations, and we've had some success in that area in smaller matters, but not in larger matters. And the more times that you can do that with hearings that shine a spotlight, that's another power of the legislative branch to put a check on the executive branch. Sometimes that embarrassment causes changes. Sometimes it's ignored. The more times that you can pass laws and put them on the president's desk, which given the construct and the mindset of the current Senate and current Senate Majority Leader has been increasingly hard to do, certainly in this Congress, but in another Congress with a Republican majority, it might also have that impact. The more you can bring public opinion to bear on the situation and demand and require that something be done. But to me, probably as equally appalling as the president's abuse of power in dozens of different areas, you described again a number of them in your remarks, is the appalling lack of concern about this on the part of many members of the Congress. I mean, when the president came 2.5 years ago to the Congress and gave his State of the Union address and had, as all presidents do, a long list of things that he thought needed to be addressed to solve, issues before the nation, every president does that. But at the end of his, he said something that just totally stunned me. He said, "And if you don't do it, I will." And then this year, he said, "I've got my pen and my phone." And he's not only said these things, but he's shown, in many instances, willing to do that. But when he said that this year, many members of his party, of both the House and the Senate, stood up in the House chamber during the State of the Union address and gave him a standing ovation for the very statement that he would seize power, Article I powers of the Congress, and essentially transfer those to himself to take action on. So the public needs to get concerned. And we started this process last year by calling into question the importance of separation of powers and the rule of law, and started holding a series of hearings. That has led to the decision on the part of the leadership that a lawsuit would be appropriate. I happen to think that it's important to get the courts to be more engaged in protecting the separation of powers and be more engaged in respect for the rule of law. So if you have the courts on the sidelines saying, "Oh, these are political controversies between the Congress and the executive, and we're going to stay out of them," you don't bring to bear all of the different forces that could hold a president in check. If you do convince the courts that their view of standing needs to be open-minded when an entire body of the Congress, either the House or the Senate or both, brings a lawsuit, that they should not only step up and take those cases, but also do it in a more expeditious fashion, I think that the court does have a role. Obviously, they don't have an army. They don't have people to carry out enforcement. Neither does the Congress, for that matter. But working together, these two branches of government should both take on the responsibility of attempting to put in check the president. And if they do that, and the public sees that, and agrees with the decisions, like I think they overwhelmingly did with his recess appointment case, and we're working now through the fast and furious subpoena case and so on, the more of these you can do, the more the ultimate judgment in this country and the ultimate check against the president, the judgment of the people, can be brought to bear in all of these different ways that we've discussed. So yes, I don't think any of these tools are perfect answers to this, The only perfect answer is for the public to stand up and say, this is an abuse of power and we're not going to stand for it any longer. That can be reflected in elections in this election cycle. I had hoped it would be reflected in elections in the last election cycle, but unfortunately I don't think we were talking about this enough back then, and the president's abuse of it I don't think was as apparent back then as it's become since then. But be that as it may, we should use all the tools that we can that will work to put into check the power of any president that exceeds his authority under the Constitution.
You know, it seems to me one of the you know, when it comes to public policy, the locus of evil in the administration is the Department of Justice, which you have oversight over. The Attorney General's willingness to rewrite sentencing laws on his own, even though Congress hasn't written those laws in a way that would give him the power to do so. The refusal to enforce the law or defend laws like the Defense of Marriage Act. You know, that attitude is not just about in terms of the federal abuse, either Congress being usurped or allowing itself to be usurped, or the President and the Attorney General taking it upon themselves to exercise veto by refusing to enforce laws, is that it's the viral nature of this. We see governors in Virginia talking about doing the same thing, where the Attorney General encouraging other states' Attorney Generals to not enforce marriage laws. And you can imagine a whole series of laws that they don't want to necessarily enforce. That failure to enforce the law, as opposed to, quote, explicitly violating it, is kind of a unique challenge. Well, I shouldn't say unique, but a more apparent challenge for this administration than we've seen previously. And obviously it's become a political movement among the left in terms of policy of public office holders. Do you have any comment on the Department of Justice generally, or the issue generally, and obviously you as a former DOJ attorney?
Well, let me say this. I think Congressman Goodlatte in his last round of remarks at the beginning hit on what the nub of the problem is, which is prosecutorial discretion. When I was a prosecutor, this was an unremarkable doctrine. And basically, prosecutorial discretion is simply a resource allocation doctrine that is peculiar to the criminal law and the enforcement of the criminal law, on the theory that we neither can nor should, under circumstances where we're a freedom-first society that believes in the rule of law and we have finite resources, enforce every single law and prosecute every single crime, and it's common sense. So what prosecutors across the country have always done is draw sensible lines about where to allocate the finite resources toward the most important crime problems in a particular area. So for example, when I was a federal prosecutor in New York, the feds and the states have concurrent jurisdiction over the federal narcotics laws and violations of them. The feds have a particular ability that the states don't have to go after large-scale international and interstate narcotics trafficking organizations. So we focused our efforts for the most part on that and left mainly to the states things like street sales of narcotics and possession of narcotics. By doing that, the feds weren't saying that possession of narcotics was no longer a crime. They were just simply saying that the best use of our resources is to attack these different areas that the states have trouble with. And that was a totally uncontroversial doctrine. What the Obama administration has done is perverted the doctrine of prosecutorial discretion by first taking it out of the area of criminal law enforcement and basically applying it across the board, and secondly, using it as a license basically to repeal laws that the president doesn't agree with. I think everybody who is at all versed in constitutional law would agree that the president, at least until the courts resolve a legal controversy, has the authority not to enforce laws that he has a good faith belief are unconstitutional. However, the President Obama, is not refusing to enforce laws on that ground. He is refusing to enforce laws on the basis of a policy disagreement with what Congress's laws state. And he is using prosecutorial discretion as the camouflage to suggest that that is constitutional. And it's actually, I think, flagrantly anti-constitutional and unconstitutional. The president's first obligation domestically is to take care that the laws be faithfully executed. And if the president does not have a good faith basis to think that a law is unconstitutional, and we're not in the peculiar law enforcement situation of allocating resources, he must enforce the laws as written, whether he agrees with them or not. And it's frankly strange to me that we regard this as at all controversial. There's not a Supreme Court justice or a Supreme Court nominee who's not brought before a Senate committee for a hearing who isn't asked, Roe versus Wade, you have to apply that. Even if you philosophically disagree with that, you don't have a problem with that principle, right? And virtually every judicial nominee says, well, yes, that's exactly right. I have to follow the law regardless of what my personal policy preferences would be. The president is in no different position, and I would argue is actually in a worse position because he takes an oath to execute the laws that we have faithfully, and if he doesn't execute the laws that we have faithfully, the whole system collapses. So I appreciate that Congressman Goodlatte went into prosecutorial discretion because I really think it ends up being the heart of the problem.
The Attorney General and the Justice Department's role in all this, obviously an enabler, is, I don't know, will you be chairman, assuming a majority next year?
Well, that's decided by each Congress, but generally speaking, if I have the support of my colleagues, I'll be continuing as chairman.
Right.
Let me just say a couple of things that Andy noted. The Arizona case, we've passed legislation through the House to restore that authority, but of course it's got to go through the Senate and be signed into law by the president. So the legislative power is very much weakened when you have an entire half of the Congress that isn't willing to assert itself to protect against those kind of abuses or to protect the states. I mean, basically, he's right. The Arizona case was kind of a split decision. The court said immigration is under control of the federal government, and the federal government has to give authority. But you gave authority through a program that allows the states to have involvement, and the next day, they basically kicked Arizona out of that. So we've passed a bill that says Arizona will have a statutory right to be involved and participate. We've also passed legislation to make sure that the courts don't use judge-made standing as opposed to the constitutional requirements of standing to avoid making these decisions and to give it to a 3-judge panel and then go directly to the Supreme Court, which would expedite this process, because another criticism of a lawsuit is it could take a long time. But we're doing this for the long-term protection of the separation of powers, not for any one particular issue, because there are dozens, we could file dozens of lawsuits. We don't think that is the right way to go about this. We want to pick one that has the best chance of getting standing and getting a positive decision, and then have the court of public opinion as well as the remedies that the court has and the Congress has to impose penalties on a president if he ignores that and doesn't support it. But again, all of these things are being thwarted when the Senate will not take action to protect the powers. In fact, the Senate, gave away some of its powers to the executive branch when they lowered the threshold for the approval of judicial nominees and executive branch nominees and ambassadors last year. So all of these things are a major challenge, and that's why we think it is well worth trying to bring the courts in to this process as well. Not that this alone is the the be-all and end-all of the problem of a president who is abusing his powers, but we need to find people willing to stand up for the Constitution, and we're hoping that we can find some in the courts that will do that.
Well, we have time, I think, for one question and 2 quick responses from our guests. Does anyone have a question? Yes, Fred here. We have a microphone here. You identify yourself, Fred.
Yeah. Thanks. Fred Lucas with The Blaze. Wanted to ask, as far as the possibility of impeachment goes, and if I can jump 2 questions in here, do you think the public could ever view, violation of separation of powers in the same light as they could view crimes such as, perjury, obstruction of justice in that same type of light in terms of an impeachment? And also, I guess the second question is carrying the separation of powers over to another topic going on right now. Do you think the president would definitely need to get congressional authorization if he extends the fight against ISIS into Syria?
On the first question, I think if you understand what high crimes and misdemeanors are, while the separation of powers is crucially important, it's hardly the only one that we're dealing with. I mean, it's quite true that the president has serially failed to enforce the laws as Congress has written them. To me, the most shocking transgression by this president involves Benghazi, which is a profound dereliction of duty, even though it's not an indictable offense. And it is simply a fact that a president does not have to be indictable in order to be removable. But I think if the question is, would the public ever be outraged enough by violations of the separation of powers to be of a mind that the president should be removed, I don't know if it would or it wouldn't, but there's no need to ask that question, because once you know what an impeachable offense is, once you know what high crimes and misdemeanors are, and you realize that dereliction of duty is part of the concept, and you look at a president who doesn't defend Americans under terrorist siege for hours, notwithstanding that he knew from the earliest part of the assault that a terrorist attack was underway. And then you go through other things like Fast and Furious, where you have a Justice Department that actually armed violent Mexican crime syndicates intentionally in order to try to make cases. Yeah, separation of powers is a big problem, but it's hardly the only one.
Chairman?
Well, separation of powers is an abstract concept, but it applies to very real things that impact people. So if they feel the lack of the president carrying out his responsibilities, they could definitely react to a president in a way that could yield to wanting to see a lot of these different powers. I mean, we attempted, for example, with regard to Obamacare, to defund it, exercise the power of the purse. But the public, which has never supported Obamacare, nonetheless became in significant numbers distracted by the concept of the government not being able to work this out some other way and so on, and the fact that certain services were not available to certain people for certain periods of time, instead of being focused on the long-term view that both from the standpoint of fiscal responsibility and the standpoint of the fairness of how Obamacare works, it's a bad idea and it should be halted. But in attempting to do that, we did not command that kind of public support. Had we had that kind of public support, I think the president would ultimately have had to bow to that pressure. With regard to the matter in Syria, well, this is, as I said in my remarks, the area where the President of the United States has his strongest stand. He is the commander-in-chief of our armed forces under the Constitution. However, the war-making power is reserved in Article 1 to the Congress. So this has built up over a long period of time tensions as to what is appropriate action on the part of the president. Most people recognize that there are certain circumstances when the president needs to act very quickly, and it wouldn't be possible to bring the Congress together and get them to debate and pass a resolution giving them authority to do certain things. On the other hand, other longer-term objectives that do allow for time for the Congress to be consulted, we think require that the Congress be consulted. So over time, we've developed kind of a way of understanding this. Both George H.W. Bush with regard to the original war in Iraq, and President Clinton with regard to Bosnia, and President George W. Bush with regard to both Iraq and Afghanistan came to Congress and didn't get a declaration of war, got an authorization for use of military force. President Obama did not do that when he engaged in Libya, and when he then sought to do that in Syria, he got tremendous blowback, bipartisan blowback in that case. So I think that if he's going to take action in Syria, for example, now, or in a broader range of actions, he should seek the Congress's authorization to take those actions. And I think that given the environment that we're in right now, depending upon what exactly he asks for, he'd be likely to get bipartisan support for authority to take certain actions.
Well, you know, just let me conclude, and I appreciate both of your excellent presentations and commentary and the time of all our audience. But in terms of the power of the purse, which is largely gone unremarked upon, I think if the discussion became more about following the law and less about government spending, there would be a lot more political support for some of the actions in terms of cutting off the president's lawlessness, and I think it's something to consider in terms of future debates. And, you know, secondly, there are other ways in terms of holding the president to account. In the United States, we have a vibrant civic community outside the control of the state. They don't have organizations like Judicial Watch in France or in the United Kingdom. Frankly, Andy, I don't think you'd be able to get a book like that published in too many places in Europe if you're a citizen of a European country. I mean, the fact remains that citizen oversight remains a powerful tool here in the United States, and I dare I say it, Judicial Watch shows that under the Freedom of Information Act, you can get information out that the media ends up having to pay attention to, and that Congress is forced to grapple with and take ownership in and follows up on in ways that I don't think the founders would love. And so there are tremendous opportunities available to us to police this president and Congress and other members of the political class here in America still, despite all of our agony about the current state of affairs. So I just tell you this is not a well-known fact, but Rod Blagojevich, the governor of Illinois, was impeached. And one of the counts for his impeachment was a failure to respond to a Judicial Watch FOIA request. Okay. So, you know, I guess that's the dream impeachment of Obama, but you know, but that lawlessness with respect to transparency, again, an issue that cuts across party lines. The failure to follow the law, the failure to be transparent, to follow the rules, that's something that, as we've all discussed, is an apolitical or should be nonpartisan. And, you know, Democrats love Judicial Watch when we were suing Dick Cheney in the Supreme Court, relatively speaking, over Energy Task Force documents. And certainly now that we have this administration in court over FOIA, you know, the other side likes us a little bit more. But, you know, the fact remains we need independent oversight of this government. And if Congress isn't going to do it, not for want of trying, but because of the political nature of Congress and just the institutional system, the way it's set up, and failures, we've got to step into the gap. And so this is why Judicial Watch is holding educational panels like this to try to hold members of Congress to account, hold the president to account, hold the media to account, because the Justice Department isn't going to do the work. Congress only in part can do the work, and certainly, as Andy knows, the media is largely afraid of even talking about these issues. So we're going to keep on pursuing them, and I encourage any member of Congress following this story to make rule of law an important issue, because it will impact the country in ways they can't even imagine if politicians they don't like get into office. And so we appreciate your attention here. We appreciate the time of the chairman and, of course, Andy McCarthy, who has spent a lot of time following these issues as well. And you can track Judicial Watch's efforts to keep this president and every other politician accountable at our website, always at judicialwatch.org. Congressman Goodlatte, I'll let you put out your website so people can understand how.
Goodlatte.house.gov.
Goodlatte.house.gov. And Andy?
What are we, nrinstitute.org, and my website is andrewcmccarthy.com.
That's right, and the book's available, and so we'll see what happens over the next few weeks and next year with the court case, presuming it goes forward. But in the meantime, lots of other court cases to be following as well through us. So we appreciate your time. Thank you very much.
Thank you.
Hey, thanks. Enjoyed it very much.
Appreciate it. Thank you very much.
Appreciate it.
Thank you, Andy. Great work. Thank you.
I've got it.